So thank you first up for the invitation, and thank you for the two prior presentations, which were really great. So I want to talk about the relationship between information self-determination provisions and data security in relation to health research. Often discussions of informational self-determination provisions in data protection law applicable to research are accompanied by supplemental discussions as to what the implementation of data security measures, rather broadly understood, can do in terms of modulating the scope and applicability of these provisions. These discussions take a number of different forms and they rest on a number of different presuppositions. They're probably familiar to most of the audience. One example is the discussion as to the degree to which the implementation of data security, in this case anonymity measures, can function as a withdrawal to, or as a response to the withdrawal of consent by a data subject or a research subject. Another example is the discussion concerning the degree to which the implementation of data security measures can serve as a safeguard legitimating the relaxation of normally applicable conditions to obtain specific informed consent under certain circumstances outlined in Recital 33 of the GDPR. So these supplemental discussions on data security, however, tend to proceed without clarifying the contours of the relationship between, on the one hand, informational self-determination provisions, and on the other hand, data security. It may well be that the discussants feel that the structure and basic tenets of this relationship are already clear and in need of no further explanation. I'm not sure this is the case, and with this in mind, this presentation is an aim to provide a sketch of a structure through which we might understand this relationship and to point out certain key features in this relationship. So the first thing you recognize when you look at this relationship between informational self-determination provisions and data security measures is that the relationship is complex, it's multifaceted, and it's tendentially quite confusing. So in order to address this melee of issues and complexity, we need a structure through which to present the analysis or through which to conduct an analysis. I think one way we might think about doing this is to break down the function of informational self-determination provisions as they apply to research into three different layers. So look essentially at these provisions from three different perspectives. First perspective is the fundamental perspective. What is it that these provisions are essentially trying to do? The second perspective is the contextual perspective. What other kinds of legal and social prerequisites do these provisions exist alongside, and how do these other prerequisites or other legal obligations restrain the function of informational self-determination provisions? And finally, the third layer is the technical layer. So what conditions do informational self-determination provisions place on securing legitimate informational self-determination? And in relation to then each of these perspectives, we might consider how how data security measures and the implementation of data security measures might then serve to adapt or modulate the applicability of informational self-determination provisions. So against this background of structure, we'll jump into the first perspective of analysis, which is the fundamental perspective. So the applicability of any informational self-determination provision in data protection relevant to research essentially reflects a political choice to give control over some aspect of personal data in relation to some proposed or ongoing research process to a research subject or a data subject. And in this perspective, essentially the research subject, the data subject, is put in the position to freely make their own evaluation as to whether the processing proposed or ongoing is desirable in their eyes. And you can consider this evaluation process itself from two different perspectives. The first is the risk-based perspective. This is the perspective that is really overwhelmingly considered in data protection discussions and has been in data protection discussions up to now, both in academia, I think, and also in jurisprudence. And under this perspective, the data subject, the research subject, is essentially conceived to be considering whether the risks implicated by the proposed research processing are of an acceptably minimal level that they're willing to take those risks on. The second perspective, however, is the normative perspective. And under this perspective, the data subject is essentially considered as engaging in an evaluation as to whether they feel the processing proposed or ongoing is normatively desirable. Do they feel that it's a good thing and something that they wish to support through the medium of donation or allowing the continued use of their personal data? So what does this consideration of the fundamental perspective of informational self-determination provisions tell us about the interaction between informational self-determination and data security measures? Essentially, it tells us, I think, that data security measures can't function as a substitute for informational self-determination when informational self-determination's provisions would otherwise be applicable. And second, it tells us that data security measures can't function as a holistic response to the exercise of informational self-determination. And the reason for this is, whilst it's true that data security measures can interface with the factors of processing definitive of the risk-based perspective, they'll tendentially do very little in relation to the normative perspective. Addition of supplemental data security measures isn't going to make a research or a type of research activity normatively more legitimate in any way. So with that, we move on to the contextual perspective. So informational self-determination provisions in data protection applicable to research exist within a broader legal context. So they exist alongside a whole series of other legal provisions regulating precisely the same processing applicable at precisely the same time. And this means that informational self-determination provisions, while they in principle confer choice onto an individual, they don't confer unfettered choice. Now, these other principles are found, or these other provisions are found in other areas of law, not data protection, but they're also found in data protection itself. And one of the provisions found in data protection is that the researcher or the research institution is obliged to secure a baseline level of data security in relation to all their processing activities. Now, what does that tell us about the relationship between informational self-determination provisions and data security measures? Well, it essentially tells us that informational self-determination measures can't remove the obligation to ensure a baseline level of data security in all processing contexts. That's a rather terse conclusion and relatively self-explanatory, but I think it bears repeating. And the idea of a baseline level of security applicable in all contexts further feeds into the analysis of the technical perspective, which we jump into now. So essentially, in the technical perspective, informational self-determination provisions outline conditions limiting what constitutes legitimate informational self-determination. And these provisions are dotted around the GDPR, for example, in Article 7, Article 413. They're commonly known that, for example, that consent must be informed, that consent must be freely given, etc., etc. Now, in normal processing contexts, these considerations or these conditions are elaborated quite extensively in law and jurisprudence. And what does that tell us? Well, it tells us that, or what does that tell us about the relationship between informational self-determination provisions and data security measures? Well, it tells us that data security measures above the mandated baseline are likely to play little role in influencing the applicability or the compliance with these conditions. And this is true for two reasons. The first is that the conditions are already relatively well elaborated in law and jurisprudence and don't leave particularly much space for the modulation via supplemental safeguarding measures such as data security. And the second reason is that the conditions tend to relate to the substance of the relationship between the research subject and the research institute or the researcher, and the substance of the communication that happens within this relationship. And this is not the substance, this is not the kind of phenomenon that traditional data security measures actually interface well with or adapt well to. Now, that's in a normal research processing context. There are, however, special contexts in EU data protection law where the conditions of legitimate self-determination can be relaxed subsequent to the presence of certain types of safeguards. Of course, I'm speaking very specifically about the possibility under Recital 33 that consent obtained by a researcher or a research institute need not necessarily be specific informed consent, provided that this isn't possible in light of the research proposed, and provided that certain safeguards are in place such that data subjects' rights are protected. What does that tell us about the relationship between informational self-determination provisions and the implementation of data security measures? Well, it itself doesn't actually tell us very much, but there is, however, guidance that confirms that the implementation of data security measures can constitute relevant safeguards which serve to legitimate a relaxation of conditions following from Recital 33. Guidance is available from the European Data Protection Board and now also from certain national DPAs, including the German Datenschutzkonferenz in their opinion on broad consent. Now, up to now, this guidance has tended to be a little bit scattershot in just talking about data security or talking about data security and listing some general types of data security. I think there's a caveat which can logically be added to this guidance, and that it's this: only data security measures which actually serve to ameliorate the risk raised by the loosening of the specific informed condition should serve as safeguards which legitimate the use of Recital 33. It doesn't really make much sense. To put it this way, under Recital 33, there are certain raised risks for the research subject, the data subject, and these relate to transparency. It's that the data subject doesn't know what's going to happen to their personal data because that information isn't available at the time that, say, consent is given. There are lots of different types of informational or data security measures, many of which don't have any relation to this risk at all. So it's hard to see, for example, why a raised level of above the baseline, which would be mandated anyway, a raised level of security concerning illegitimate third-party access should serve as a safeguard which can legitimate the use of Recital 33. Now, there's a really legitimate question you might ask in relation to that, which is why not simply require a higher security standard across the board in a condition or in a state where certain otherwise applicable protections are relaxed? Surely this would be a good thing and secure better data subject, research subject protection. It's completely true. However, more security will naturally come at a cost to other interests in the research process. Security, a higher level of security will require diversion of resources which would otherwise be spent on other activities supporting research. Now, there is already a baseline level of security which should required from researchers, research institutes. And this should already reflect a balance between the rights and interests in research. Now, this balance should only necessarily be disrupted if there's a specific reason for that disruption. Simply generally requiring a high level of security doesn't reflect a specific reason, and therefore I don't think is particularly justified. So with that in mind, I draw certain general conclusions and wind up. Informational self-determination and data protection applicable to research is often discussed sort of in the same breath as data security. And despite the relationship between these concepts actually being quite complex and multifaceted, the basics of this relationship, the structure, the key principles that should regulate this relationship actually seem to be seldom considered. So this presentation sought to provide an overview and some conceptual clarity as to aspects of this, the structure of the relationship, and as to its key defining principles. And I hope, with that in mind, this can be useful for further discussion of the topic. Thank you.
Thank you so much. That was an incredibly interesting presentation.